Can everybody hear me? It's coming in on the... Okay. First of all, thanks for having me here. It's an honor to speak. One word of caution is I'm not a scientist and I don't have a technical background. My father was a chemist. My sister's a chemist. I didn't inherit that gene. I inherited the skiing, motorcycle, and, well, I shouldn't get into all of it, but anyway, in preparing for this presentation, it was real interesting because it kind of made me go back through the adjudication and look at cases that we had and look at remote sensing technology and the different aspects where it's been applied in the adjudication. And then last week I was at a conference in San Francisco, or in Sacramento, regarding the Sacramento Delta, and took a field trip out on the Delta, and was introduced to a couple of different concepts that I didn't even know existed and to my knowledge aren't being used in the SRBA, but the one was the use of the sonar sensing for measuring flows, and I'm probably, right here, you probably all are well familiar with that. I see heads going up and down, but for me, that was kind of new. The interesting thing about that is that the sensors would text the employees when they needed to have repairs done. So I thought that was pretty interesting. And the other interesting thing was the measurement of aquifer levels using, taking gravity readings from satellites. That's, I see heads shaking again. Well, anyway, like I said, I don't have a technical background, but I thought that was fascinating. What I want to do is talk a little bit about, from the 50,000 foot elevation, a little bit about what I do, and how the remote sensing has been involved in the adjudications. And so I'm going to talk, give you a brief contextual scope of the adjudications and administration in Idaho, kind of to give you some context. You've kind of heard bits and pieces, but maybe this will put everything together as far as the process goes. Examples of remote sensing in the adjudication process, remote sensing in conjunctive administration of ground and surface water rights, and then the legal considerations, which I know you have, as far as the admissibility of expert testimony. I know you've had quite a bit of discussion on that already. Let me start out. How many people are not from Idaho? Oh, great. Okay, good. Then this will really make sense. Or it won't make sense, depending on how you look at it. Again, Idaho's a prior appropriation state, as is most of the western states. It's difficult to administer water rights in priority without a comprehensive inventory of who has what. This is what we have going on now in the state. This is, you've heard reference to the Snake River Basin adjudication, covers 87% of the state. The blue is the geographic boundaries. Here's the Coeur d'Alene Spokane River Basin adjudication, which was commenced in '08, about 13,000 claims. Step back, the Snake River Basin, when we're done, will be about 159,000 claims. Also, hopefully on track that for adjudication, which has been authorized but not funded, is the Clark Fork Pend Oreille adjudication and the Palouse River Basin adjudication. So that's kind of gives you a scope of what I deal with. What are we adjudicating? Those are the statutory elements of a water right. Leaves lots of room for disputes. Won't go through them, but give you an idea of what we adjudicate. Brief overview of the adjudication process. I had a couple people ask me about this. This is very brief. The water user files the claim with the Department of Water Resources. Department investigates the claim. Department files a report and recommendation with the court. That recommendation is given prima facie weight. And then the claimant or any other party to the adjudication can object. And as we'll see, remote sensing and science has definitely played a role in this process. Administration of rights. Once the rights are all adjudicated, they're put into water districts for purposes of administration in accordance with the decrees that we've issued in the respective adjudications. Ground and surface water are administered conjunctively, as Justice Schroeder mentioned in his lunch speech. And then I just threw that editorializing in there. It's easier to say, trickier to accomplish. Obviously, that requires science and technology. Remote sensing in the investigation of water right claims. In the investigation of the claims, the department used the NAP photography in 1987 as part of the claims investigation process for all of the water right claims. Not infrared imagery wasn't available for all, but where it was, they used infrared. Obviously, the absence of any discrepancies between the claim description and the imagery reduced the need for on-site field investigations, or at least narrowed the scope. My understanding is they did do on-site field investigations for all irrigation rights, but that may change as we get into the Coeur d'Alene investigation in the Coeur d'Alene Spokane River Basin adjudication. Again, taking advantage of technology. Here's one of the cases I dug up. Had a case involving a city that claimed a municipal purpose of use for a biosolids program on land that was licensed previously for irrigation. The city had to prove that it had used the land for biosolids prior to the commencement date of the adjudication, which is 1987. And the imagery showed the existence of runways, because it was an old airport, showed the existence of runways where the pivot was allegedly located for the biosolids program. And as a result of that competing evidence, the city lost. The city introduced evidence post-1987 that showed the pivot in place, aerial photography, and then the objectors came in with the aerial photography of the runway. Place of use disputes. Get this all the time in place of use disputes. One case, fairly recent case, dealt with infrared imaging that depicted a place of use, and it came out that it was very swampy. The result was the claimant's place of use was reduced proportionately by that area that was depicted in deep, deep red as being swampy. In another case, the infrared images showed presence of noxious weeds and sagebrush, resulted in a forfeiture of the place of use. Here's one where the use of remote sensing and imagery backfired a little bit. It was in a claim, federal claims made by the BLM involving hundreds of stock water rights on grazing allotments. And rather than go out and physically investigate the existence of all of those water sources, they just used aerial imagery depicting vegetation, and then based on their interpretation, drew the conclusion that there was a water source, surface water source there that was available for stock watering. The objector went out and physically field site investigated all of those, and many of them, about 160 of them, did not have actual surface water on them. The court held that the pre-filing reasonable investigation requires a field investigation. And where this came about was after the BLM withdrew its claims based on the determination that there was no water at those sites. The issue arose regarding attorney's fees and whether or not the BLM did a sufficient investigation, good faith investigation prior to filing its claims. I think they settled that out. No attorney's fees were awarded. Been used as assertion and defense to forfeiture. This is in one case where we had an objection filed asserting forfeiture based on two aerial photographs, one in '84 and one in '87, one showing no irrigation and in the 1987 one showing only partial irrigation. The objector was asserting forfeiture. Forfeiture period in Idaho is 5 years. The claimant introduced infrared Landsat imagery for summer periods for the relevant periods 1974 and 87, showing the irrigated acreage. Also, in addition to presiding over the Snake River Basin adjudication and the Coeur d'Alene-Spokane River Basin adjudication, the Idaho Supreme Court graciously assigned me the task of hearing all the administrative appeals from the Department of Water Resources, so statewide. So even though I live in Jerome County, Idaho, bench in Twin Falls County, I hear all the administrative appeals statewide. So I have the opportunity to review the findings of the Department of Water Resources in these various administrative transfers and enforcement actions. But you know, they use the remote sensing in the transfer of water rights. You know, there's a no injury rule with respect to transfers. A senior cannot transfer a water right. This is particularly important on the Eastern Snake Plain Aquifer that Justice Schroeder addressed earlier, where it's all groundwater pumping. Senior can't transfer water right from one place to another if it's going to injure a junior groundwater pumper. Typically only the consumptive portion of the water right can be transferred. Conveyance loss and water that returns to the system cannot. Remote sensing data was used to calculate the consumptive component of the right for purposes of evaluating the transfer. Is everybody still with me? A little bit? Here's a case you've heard of, and my understanding is you've discussed quite at length, the A and B case. And just to set the context, you know, the irrigation district filed a delivery call alleging injury to its groundwater right from pumping by other groundwater rights. The director found no material injury to A and B's water right, despite A and B not receiving the full decreed quantity. The director's finding relied in part on the remote sensing data showing the evapotranspiration was the same as that of the district's adjacent lands that were not claimed to be water short, and that's one of the exhibits in there, and that shows A and B's different places where it's irrigating within the project, and the pink shows the ET was not lower than those other lands. The one point that I wanted to emphasize, and I don't know to what extent or how deep into the case you got, was that the evidence of the ET was weighed along with the other evidence that was introduced in the case. I mean, it was not in and of itself dispositive. The director also looked at the delivery system that could never have historically, or found that it never historically delivered the full quantity of the claim. There was efficiencies made to the system before subsequent to the right being licensed. You know, leading to the finding that not all of the water was necessary, and then also A&B had irrigated additional lands that were not within the boundaries of the original right. The significant thing that came out of that case also, and it's not done, it's gone up and come back down, but one of the significant holdings that came out of this case, and this is where it affects what you're all doing and what you're here for today, deals with the burden of proof. And you know, the conclusion was made that, let me step back, under Idaho's conjunctive management rules, the director has to make a when a delivery call is made, the director has to make a finding as to whether or not that right is being materially injured. Meaning, is there sufficient water to satisfy the crop needs or whatever the purpose of use is? And he has to make that finding before he can order any curtailment. Just because your water right is decreed for a certain quantity, if you can't, if you can satisfy your crop demands on less water, then I won't make the flat-out statement, but there is always the consequence of your right not suffering material injury. The issue in that case, though, one of the issues dealt with what is the burden of proof. Originally, when the director made the finding, taking into account all of the evidence, including the ET, made the determination based on a preponderance of the evidence. Well, one of the issues raised on appeal and went up to the Supreme Court is that the appropriate burden of proof? And there was an argument made that it should be clear and convincing evidence, which is a much higher standard. In other words, if you're going to cut back or allow juniors to pump out a priority, then there ought to be a determination by clear and convincing evidence that indeed there is enough water for the senior to have sufficient water for crops. Of course, that's going to play into the role in, I'll talk about that in just a minute, but like I said, the burden of proof is significant, and that's going to present itself in another case. Briefly, conjunctive management, like I said, it's easier to say, trickier to accomplish. As Justice Schroeder was discussing, the ESPA, Eastern Snake Plain Aquifer, 170 by 60 miles, billion gallons of water, roughly compared to the size of Lake Erie, is hydraulically connected to the Snake River. And in order to conjunctively administer the water, there's a Eastern Snake Plain Aquifer model that was developed to simulate the effects of groundwater depletions on various reaches of the river. My understanding is they used the remote sensing data in the calibration of the model. The model divides up the Eastern Snake Plain, the area over the Eastern Snake Plain, into 1 mile grids. And that model is what's used in the delivery calls. And I don't know if, has there been any discussion about the Clear Springs delivery call? Good. And this is one that Justice Schroeder was the hearing officer on. And in that case, Clear Springs and Blue Lakes, two fish producers who diverting out of some of the springs that are fed by the Eastern Snake Plain Aquifer, filed delivery calls against groundwater pumpers on the Eastern Snake Plain Aquifer. The director at this time did find material injury to the senior water right holders. In applying the ESPA model to simulate the effects of the groundwater pumping, that's when as a result of applying the model, the director ordered curtailment of 52,470 acres to provide 38 CFS to the reach gain, resulting in 2.7 CFS increase to the spring. That was for one of the claimants, or one of the parties making the delivery call. The other one, he ordered curtailment of 57,220 acres to provide 51 CFS gain to a different reach, which would result in 10 CFS increase to the spring. And this is where we get to the impact on the scientific evidence. The Supreme Court upheld the use of the model, finding that it represents the best science available. However, one of the big issues in that case that never got decided, and for reasons I'll explain, was the allocation of the margin of error. And who should that margin of error operate in favor of? The way the model was applied, the acreage that was curtailed was within the margin of error. In other words, the directors concluded they applied a 10% margin of error to the model and ordered curtailment based on that margin of error. If the margin of error wasn't taken into account and it operated in favor of the parties making the delivery call, there would have been substantially more groundwater that was curtailed. The opinions discuss at length going into the Eastern Snake Plain Aquifer model, and that how it is the best science available, and ultimately Supreme Court upholds it. But getting back, one of the issues that was raised by the Clear Springs and Blue Lakes, again, was if you operate that margin of error in favor of the juniors, then there's impermissible shifting of the burden of proof on the seniors. Well, the seniors did not preserve that issue for appeal, so the Supreme Court never had to get to that issue. But there are several other delivery calls in line on the tarmac that are working their way up, and I assume that issue will be brought up in the fairly near future. It'll be interesting to see how it shakes out, but anytime you're dealing, and you discussed, you had a presentation on scientific evidence earlier this morning, and they went through the Daubert factors, and if you're dealing with scientific evidence and you're talking about a margin of error, anytime you're dealing with scientific evidence, or I shouldn't say any time, but presumably when you're dealing with scientific evidence, there's going to be a margin of error, and we increasingly have to rely on the scientific evidence for conjunctive management of ground and surface water. It'll be interesting to see how this all shakes out with respect to the allocation of the burden of proof. Everybody still with me? I know doing this after lunch is kind of an unenviable position. Model also used to, under our conjunctive management rules, a junior can avoid curtailment and continue to pump out of priority if they can provide mitigation or replacement water. This is done through either finding additional sources of water or fallowing ground. The model is also used for determining determining the effects, the remedial effects of the mitigation. One interesting thing is you hear a lot of it. You actually get an opportunity to evaluate the remedial effects because the director has a hearing on it to determine whether it's sufficient to get you through a season or two. But then this litigation takes so long as you go through, you can see whether or not the predictions were actually right or they weren't right. And one of, I'm going to skip ahead here, but one of my favorite sayings that gets just pushed in my face all the time is theories neither create nor produce water. So and then jumping into the legal considerations, you know, as you've already heard, and as you know better than I do, it's the remote sensing data is scientifically based, complex, and highly technical, typically beyond the understanding of the layperson and definitely this district judge. So it requires the use of an expert to explain the data and render an opinion as to how the data relates to the facts at issue. I know this was discussed earlier. Idaho Rule Evidence 104, the court has a gatekeeping function in determining the qualifications of the person to be a witness and the admissibility of the evidence. This typically requires a hearing, pre-hearing on those issues before you have a trial, so the court can make findings and a determination. I know, to my knowledge, we haven't had any cases that have dealt with junk science, but we have ordered the Daubert hearings for purposes of making these pretrial determinations, and I know that it has resulted in the withdrawal of claims on a couple of different occasions. So once the expert reports were filed and the court set up the Daubert hearing, people withdrew their claims. Standard of admissibility for scientific evidence. This is the Idaho Rule of Evidence 702. It's a little bit different than the federal rules. The federal rules include this, but also incorporate other considerations, which the Daubert factors, which the court also considers. I won't read the standard. I know you've been through it, but what our Supreme Court tells us as far as the application of the standard, you know, the expert testimony must be relevant to the facts at issue. The expert must be qualified. Court needs to look at the degree to which the methodology relied on by the expert is utilized in the scientific community, and then the data relied on by the expert is of the type reasonably relied on by experts to render an opinion on the type of facts that are at issue in your case. That's the application of the Idaho standard. The federal rules also require additional considerations, but our Supreme Court tells us that, you know, we go through and consider each of these factors as well, although not all of them have to be satisfied. You know, is the theory or methodology testable, or has it been tested? Has it been subject to peer review or publication? Does it have a potential or known error rate? There again, getting into the margin of error. Is it governed by standards or controls? And is it accepted in the scientific community? And is the expert, is the methodology reliably being applied to the facts at issue? I know you had, in the discussion of the A and B case and the discussion of the process and the evidence that dealt with the evapotranspiration and the well, let me say the examination, if you read the transcript of the examination, that to get that evidence to get that evidence admitted in front of Justice Schroeder, if you read that transcript, you will see that it goes through each one of those steps. And it kind of sets up a nice framework for how that foundation is laid. And ultimately, the expert opinion was admitted and weighed along with all the rest of the evidence in the case. And this goes along with the A and B case. I just kind of jumped ahead. It wasn't dispositive. The ET was weighed along with all the other evidence in the case. That's where I jumped ahead. And that's to wake you up. Does anybody have any questions, or do you want me to wait?